Alright, hi everyone. So in this video, we're going to be looking at the Codelfa and State Rail Authority case. So this is really the key or leading authority on frustration in Australia. Note as well that this case also deals with implied terms, which we will come back to in semester 2. So it's also the leading authority, or one of the leading authorities on implied terms. So yes, you'll be seeing more of this one. Okay, so in Codelfa, the State Rail Authority accepted Codelfa's tender in relation to excavation work required for the construction of the Eastern Suburbs Railway in Sydney. Construction of the railway was authorised by statute, which included a provision granting the State Rail Authority immunity from prosecution for nuisance. So, for example, in relation to the noise of drilling tunnels, okay, for this rail network. Now, both parties operated under the assumption that this immunity would be extended to Codelfa. And so on the basis of that, Codelfa set out a work schedule which involved 3 shifts which went around the clock, so 24/7 construction. And on the basis of that 24/7 construction, the contract included a term around how many weeks it would take for the construction to be completed. And I think it was an estimated 130 weeks based on that 24/7 construction. So it was expressly agreed that Codelfa would bear all necessary costs for the work at an agreed price, regardless of the difficulties it might encounter. In order to complete on time, Codelfa calculated it would need to work, as mentioned, 3 8-hour shifts per day, 6 days a week, with certain work on Sundays too. So the poor residents, you can only imagine how noisy this was. But yeah, so local residents obviously objected to this and they obtained an injunction against Codelfa. So that immunity which the State Rail Authority had was found to not extend to Codelfa. So the injunction was granted, and this meant that work couldn't proceed between 10 p.m. and 6 a.m, okay, on the 6 days. So it couldn't be in those hours on any day of the week, and no work at all on Sundays. So as you can imagine, this significantly slowed down Codelfa, which then raised their costs, okay? And the State Rail Authority refused Codelfa's claim for additional costs, and the dispute proceeded to arbitration. Now, the key issue before the High Court was whether the injunctions issued by the Supreme Court frustrated the contract between Codelfa and the State Rail Authority. So was that a supervening event which made the contract something radically different from what was envisaged by the parties at the time of contracting? The court also had to consider Codelfa's claim that there was an implied term that the State Rail Authority would grant a reasonable extension of time and indemnify them against additional costs occasioned by the grant of the injunctions. But as mentioned, we're not going to be looking at the implied term aspect of the judgment now. We will come back to that in semester 2. Now, in a majority decision, the High Court, Stephen, Mason, Aiken and Wilson in a joint judgment, and then with Justice Brennan dissenting, they held that the injunctions fundamentally or radically changed the circumstances of the contract such that the contract was frustrated. And note that the implied terms, part of it was rejected, part of the claim was rejected. But I shouldn't be going into that, so I won't. Back to frustration. So the court held that frustration occurred, except for Brennan, and we'll look at Justice Brennan's dissent in a moment when we do the case rating guide questions. Now, one of the interesting things about the majority judgment is that Justice Stephen's approach to frustration in the BCC case was used, okay? And Justice Mason chose to define frustration from Lord Radcliffe in Davis Contractors, and Lord Radcliffe being one of the judges that Justice Stephen referred to alongside Lord Reid. So have a look at the BCC case, the Brisbane City Council case, perhaps first before looking at this video, so that'll make a little bit more sense. And yeah, this definition of frustration is one of the key ones, so I just included it on the slide here. Okay, so there must be as well such a change in the significance of the obligation that the thing undertaken would, if performed, be a different thing from that contracted for. Okay, and I've just got a little bit more detail about the contract there as well between the parties. As I mentioned earlier, essentially Codelfa was supposed to wear all the additional costs if and when they arose. Okay, we'll come back to Mason's judgment in a moment, okay? But yeah, there's some key aspects of it there. And Justice Mason noted that you need to examine the clauses in the context of the contract as a whole here. So the clause, I guess, wasn't literally interpreted. Now, in terms of the case reading questions, so we'll go through the judgments in turn. So what do the judges say is the doctrine of frustration? Like in the BCC case, the views of Lords Reid and Radcliffe in Davis Contractors was mentioned by the judges. So the termination of the contract by operation of law on the emergence of a fundamentally different situation. In terms of the comment there about the question about what is its juridical basis, so that refers to the construction of the contract, okay, going back to that Justice Mason approach. And Justice Mason notes, this is direct quote, it is not this that I promised to do, okay, so that's the basis, the juridical basis. In terms of question 2 there, so why did Justice Brennan dissent saying that this wasn't a frustration case? Well, in Justice Brennan's view, there was no supervening event here. So the injunction was simply the enforcement of a limitation, which was obviously the resident's right to be free from nuisance, the resident's right to peace, by which it was already bound. So from the perspective of Justice Brennan, there was no supervening event because that state rail authority immunity never applied to Codelfa. Therefore, they were already had this obligation upon them. Therefore, it's not like it arose out of nowhere. Okay, so that was Justice Brennan's reasoning in relation to that. And the quote I've got from the judgment in my notes is from 409, and it literally states, the injunction did no more than enforce judicially a limitation by which Codelfa was already legally bound. And yeah, I think that dissent is quite powerful, so it's worthwhile having a read there. So what was it? Okay, so what was it according to Justice Brennan? According to Justice Brennan, this was just simply a common mistake, i.e. that the immunity would extend to Codelfa. Could Codelfa have relied successfully on mistake as the basis of the relief it was seeking? No, not at this time. And the reason being was that this time there was no remedy for a mistake as to law. Okay. Now, the distinction, I don't really need to get into this too much, but the distinction between mistakes of law and mistakes of fact, I guess, was resolved as not really that helpful or important in the David Securities case. Okay. So, yeah, you don't need to worry about that. And which is why we didn't go into it in detail in the Mistake Week. Having a look then at the next question. According to Mason, so we're coming back to Mason now, what is the relationship of the doctrines of mistake and frustration? Essentially here, Justice Mason states that if the mistake is an assumption concerning a present fact, i.e. at the time of contract formation, it's a common mistake. But if the mistake is an assumption concerning a future fact, which doesn't become evident until after the contract is actually formed, it's frustration. Okay, so, and that's why the test for common mistake is very similar to the test for frustration. Okay, so it's got those elements, same elements. The next part of the question, his judgment implies that the operation of mistake is to make a contract void. Do you think this is still an accurate reflection of the law? I think here you really just need to go back to the Great Peace shipping case, which, if you remember from our Mistake Weeks, had some support in the Australia Estates case. But note that Australian Estates case doesn't really have that great a precedent. So, you know, in Australia, with the exception of that case, it would seem to be that the preferred position is that the mistake will make the contract voidable. okay, in equity, and not void, where the assertion of a contractual right would be unconscionable in all the circumstances. So that goes back to the Taylor case, which we discussed in the Mistake Week as well. Now, with regards to the next little sub-question, Mason suggests that the mistake doctrine does not apply to mistakes of law. Does the distinction between mistakes of fact and law apply to frustration? Well, as mentioned earlier, it doesn't really even apply to mistake anymore because of that David Securities case, but it did at the time of this case. So in terms of what Justice Mason says here, if you have a look to 359 and 360, there's some neat little quotes there where he says, so the first quote says, the injunction is a supervening event, even though it does not stem from any alteration in law. And then there's another pretty neat little quote at 360, which states, even if it be a mistake of law, this is not fatal to the application of the doctrine of frustration. So does the distinction between mistakes of fact and law apply to frustration? Nope. Okay. Oh, and I just have one other little comment there too, which I already basically answered anyway, but is the distinction between mistakes of fact and law useful in cases of mistake? Well, not really, because of that Davis Securities case, but also because the distinction isn't really necessarily always clear, okay? All right, so moving on then to question 4. According to Justice Mason, in what sense was the issuing of an injunction a supervening event? Okay, so here a very different approach is taken to that of Justice Brennan. So here Mason basically says that the contract required completion of the work in 130 weeks, and the whole basis of the contract was that the works program would be for 7 days a week or 6 days and some Sundays, but 24 hours a day. And so the injunction rendered the performance of the obligations as contemplated by the contract with regards to that, work cycle, that work period. It rendered it impossible. Okay, because only 2 of the 3 shifts could actually take place. Now, why did Justice Brennan disagree? It was because, as mentioned earlier, he took the view that Codelfa had agreed to perform the contract irrespective of its difficulty, remembering that clause that I had on that earlier slide. And the issue of the injunction was not a supervening event in his view, but a judicial enforcement of a limitation that Codelfa was already bound to. So you can see the discussion of that at 409. Now, if the problem had been that the rock through which the tunnel was to be dug turned out to be granite instead of sandstone, would Codelfa have won? No, they would not, because of that clause that we mentioned earlier. The contractor had assumed the risk of informing themselves fully of the condition affecting their carrying out of the works, and they couldn't be relieved of the responsibility of completing the works regardless of their difficulty. Okay, so here it wasn't really the change in work conditions or the availability or ability to work all hours of the day. That wasn't seen as a difficulty per se. Okay, that's why it was seen as that supervening event. It didn't just make it more difficult, it changed the very nature of the contract, according to Justice Mason, but not Justice Brennan. To answer the very last question there, what did Codelfa succeed in getting by arguing frustration? Okay, so what was the remedy there? They received payment for work done on the basis of a quantum merit. And quantum merit essentially means that you're paid a reasonable amount for the value of the work that had been completed. Okay, all right, and that is Codelfa, and don't forget it because we're coming back to it next semester.